Hi, good evening, everybody. I'm Meryl Chertoff, and I am the director of the Justice and Society program here at the Aspen Institute. I'd like to welcome you to the Gildenhorn book series. We have many distinguished guests here, and I particularly want to acknowledge the presence of Joe and Alma Gildenhorn, whose generosity is the reason that we're all gathered here this evening. I see a number of familiar faces in the room, people who've been with us for other programs in the Gildenhorn book series. Most recently, we heard from Kwame Anthony Opaya, who discussed his fascinating new book on moral revolutions, and this evening will be no different. The book series provides an invaluable service by bringing together diverse and thoughtful audience to hear from a distinguished author on a subject that truly matters. And make no mistake, the conversations that go on in this book series have ripple effects that go far beyond the 7th floor of 1 DuPont Circle. Before introducing our moderator and our author, I did want to take one point of personal privilege. Many of you are familiar with the Justice and Society program, which I run here at the Aspen Institute, which for the past 30 years has conducted a summer seminar in Aspen, Colorado, on big issues of political philosophy, law, and policy. If any of you are interested in attending our session this summer, please see me at the end of the evening. We've also started a very exciting series of public programs, and I would like to invite all of you to consider coming to a March 29th, 2011 conference on civics education with Justice Breyer's colleague, the former Justice Sandra Day O'Connor, who will be giving the keynote speech. We are also planning in 2011 to have a series of conversations on a subject which have generated a great deal of heat and not very much light during this political season. Subjects like federalism, the relationship of the 3 branches of federal government, which I think we'll be hearing more about this evening, and the question of religious freedom in American society. So I hope that you will all consider joining us for this. I'm delighted to introduce tonight's distinguished guest, the author of the new book, Making Our Democracy Work, A Judge's View. The Honorable Stephen Breyer has been Associate Justice of the United States Supreme Court since 1994, and I will depart from the playbook, which would next have me announce who appointed him. Since I know that Justice Breyer agrees that who appointed a Supreme Court justice is less a predictor of future performance than the commentators might sometimes have us believe. What he would want me to tell you is that prior to his appointment to the Supreme Court and before that to the First Circuit Court of Appeals, Justice Breyer served in the 2 other branches of the federal government as the chief counsel to the Senate Judiciary Committee, working for the late Senator Ted Kennedy, and as Assistant Attorney General in the U.S. Department of Justice. And even more important, at least to me, he served in what some people today would say is the 4th branch of the federal government, as that is the faculty of the Harvard Law School. And Justice Breyer, I don't know if it was a slip of a tongue or whether it was modesty, but in a speech I heard you say not too long ago in one of your famous asides that you were, well, I'm a law professor. And indeed it is in your role as a law professor that I think that you've done a great deal in terms of providing illumination to us. You in this book and in your speeches and publications, present complex ideas in simple and lucid language. And one of my favorite examples was a speech you gave in 2006 in which you explained why the average person on her way home via the Star Market should care about the independence of the judiciary. And by the end of that speech, I was quite convinced that indeed our shopper would care very much about the independence of the judiciary. Your new book is equally lucid, using a series of cases and setting out arguments for a workable constitution grounded in history but adapting to circumstances. You showed that these decisions were defining moments for the American system of democracy, and they were moments when the outcome was not certain, but where the stakes were as high as they could be. That is, the legitimacy of the federal courts and, by extension, the rule of law. You have the bios of both of our speakers, so briefly I just also want to welcome our moderator, Jeff Rosen, professor of law at the George Washington University and the legal affairs editor of the New Republic. The LA Times called Jeff Rosen the nation's most widely read and influential legal commentator. His writing has appeared in the New York Times Magazine, the Atlantic Monthly, and in the New Yorker, where he has been a staff writer. Welcome to both. After the conversation, Jeff will open the floor to questions, and thanks all for being here.
Thank you.
Thank you so much, Meryl. Welcome, ladies and gentlemen, and welcome, Justice Breyer. It's a pleasure to see you again. This is the second of our conversations about this wonderful book, and you're in for a treat, ladies and gentlemen, because hearing Justice Breyer talk about the Constitution and reading this book is like an act of democratic pedagogy. I had the pleasure of reviewing this recently and said, what I like so much about this book is its constitutional interpretation for adults. It doesn't condescend. It presents a theory of interpretation that cannot be reduced to a bumper sticker or a political slogan, but it invites all of us as citizens to engage with Justice Breyer about the meaning of the Constitution, to disagree with him, even to argue with him, and his willingness to engage in these conversations is to me a model of what a justice should do. So let's jump right in. We have a lot to talk about, and I'll start by asking the obvious question, which is, why did you write this book?
Before answering the question, can you hear me? Is it okay? Thank you for coming. Very nice to see so many friends here. And also, President Clinton appointed me to the Supreme Court. And President Carter appointed me to the Court of Appeals. And whether that is or is not predictive of how I will decide cases, I'm grateful to both of them. Why did I write this book? I had two objects in mind, and it varies between, really partly because Harry Blackman, who's my predecessor in this job, told me two interesting things. He said, Stephen, you'll find this an unusual assignment. True. And he also said that people have an enormous thirst for learning about what the court does. They know that it affects them, but they're not quite sure how or why. And he said, no matter how many times you talk about it, you can only make the tiniest dent in the desire to find out about it. So he said, when you have a chance, talk about it. And I can only reach so many people talking. Well, try writing. I might reach even fewer. So you say, why? That's a reason. So I started with a question. And really two questions. Question one, I found it an interesting question. It's Hotspur's question. That's like it's sort of Shakespearean. I like being in that company. And Hamilton said in 56, number 56 Federalist, what are we going to do about this document? See, we've written this document, but if no one enforces it, if there's no one to say when Congress has passed a statute that goes outside the limits here, we might as well put it up in the museum. I mean, let's look at it like one of those paintings or something. Beautiful, but worthless. How do we make it enforceable? We said, well, somebody has to have that power, to have that word that the statute's no good because it exceeds the limits. Should it be the president? It could be a tyrant. Too powerful already. What about Congress? Well, Congress is fine as long as you're popular, and they're experts on popularity, but some of the provisions here, in fact, are designed to protect people when it's unpopular to do that. Unpopular people, unpopular situations. And so why would we think that Congress, experts on popularity, will say that a law they just passed because it was popular is unconstitutional? They won't do it. But we have this group of obscure people up here called judges. Nobody's ever heard of them. They're almost powerless. They don't have the purse. They don't have the sword. Perfect. We'll give them the job. Now here's the question. if they're so powerless and obscure, why will anyone do what they say? So that's Hotspur's question. I wrote this whole book just to get that question in. I mean, it's Owen Glendower, who is a mystic. All Welshmen are mystics. And that's Shakespeare's view. And he says, I can call spirits from the vasty deep. And Hotspur says, well, so can I. So can any man. But will they come when you do call for them? Now that is the question that Hamilton didn't ask. He couldn't answer it. He wouldn't have known. And I want to write half of this anyway, or close to half, explaining how somehow the country progressed from, at one time, the Cherokee Indians in 1830s were told by the Supreme Court, this land in northern Georgia is yours. It belongs to you. That was a no-brainer. I'll tell you, we'd signed about 3 treaties. The Georgians are acting illegally when they've grabbed the land, and that's the case that President Andrew Jackson said, John Marshall's made his decision, now let him enforce it. And he sent troops, and the troops didn't go to enforce the decision. They evicted those Indians who traveled along the Trail of Tears, and those who, because so many died, and those who survived are in Oklahoma. They're descendants to this day. And so I want to track that. And we've had some ups and downs. There was Dred Scott. That was not exactly a charming day in the history of the U.S. reports, probably the worst. And then there's the Eisenhower when he sent the 101st Airborne. That was a great day for law, because some of us remember that. The governor standing in the schoolhouse door, in effect, and saying those black children will not come into this white school, and I have the troops. And they don't, nor, by the way, do any of the judges. And President Eisenhower sent in the 101st Airborne. Fabulous. The heroes of D-Day, the heroes of the Battle of the Bulge. And they came, 1,000 of them, and they took the children, walked into the school. That was a great day for law. I want to tell that story. And I want to remind people what I heard Senator Reid say about Bush v. Gore, a decision where I was in the dissent. I thought it was wrong. So did a lot of other people. And Senator Reid said the most remarkable thing about it is something hardly ever remarked, that even though probably half the country, he thought more than half the country, could be, thought this was absolutely wrong, they didn't use violence in the streets. They did accept it. And now, you see, I want to tell those stories. I want people to think about them, because it's never a sure thing. And I can run into people sometimes who will say, yeah, I'm sorry they weren't in the streets with violence. That was so terrible. And I say, well, maybe. Try looking at the television and seeing what happens in countries where they do have the violence. And there we are. All right, so that's a large part of what I'm trying to do. And then there's the other part, which is what can the court do about it? The court can't do much about it, to tell you the truth. It's really an advertisement for what Merle's been doing and Sandra O'Connor. The people who can do things about it are the school systems, who can teach about what our country has been, what it's like, what the Constitution is about. It's called 12th grade civics. But that doesn't mean I'm going to let the court off scot-free. And I can't resist, and part of this, explaining how I think the court should decide cases in order to increase the likelihood that the law will work well as intended for people in the United States. Long answer, but that's basically what the book is about.
Well summarized. What is the secret to what the court can do to increase legitimacy? You have two answers. First, you say it should approach the Constitution as a living document. It shouldn't just interpret it in light of the original understanding of its framers, but it should adapt it to changing times. And second, you say it should not view itself as the only actor in the constitutional system, but it should be a partner of Congress and the President and think pragmatically about the effect of its decisions on the other branches. And that's the core of this very interesting pragmatic philosophy you're spelling out. I want to ask how that applies to some of the cases in the book. And since you mentioned Bush v. Gore, I wasn't going to mention it, but I can't help asking. The people in the majority, didn't they think they were being pragmatic? They thought there would be a catastrophe if the court didn't jump in. They said there'd be a short time for a presidential transition. There'd be a lot of chaos. It would be messy. Weren't they doing just what you suggest, pragmatically trying to think about their role in interacting with the president and Congress? And if so, is that a question against pragmatism?
Here's where he has a difficult problem, because he wants to get me to talk about that case more than I have. and so what I will say, so don't tell him, but this is just a way of shutting off the discussion. The best people to ask about what the majority was thinking at that time are the members of the majority, of which I was not one.
I don't have to ask them because they gave interviews about this. And
Okay, go ahead, whatever it is, that's fine.
Sorry, you introduced this. I was going to talk about the Cherokee Indians.
Let's go to the Cherokee.
Justice stood up right after Bush v. Gore and said, the court's armor is not some kind of trophy to be put over the fireplace. It's working armor meant to be used in battle. And Justice Rehnquist, he wrote that wonderful book with your editor, Pat Haas, is here. He says in his book about the election of 1876, sometimes when both branches are begging you to step in, it may be very hard for the court to say no. So weren't Rehnquist and Scalia being pragmatists just the way that you suggest the justices should be?
Maybe. I mean, that's not the necessarily. I didn't look. I'm not saying every pragmatist, including me, is always right, and I'm not saying really pragmatism is more than a slogan, and I'm not saying whether that particular case was pragmatic or not. If it was, I still wouldn't have thought it was right, and if it wasn't, I might have thought it was wrong. Regardless, there were special reasons why I think they're wrong related to the case, and there we are. The pragmatism is a tough word. So what you're forced to do, which is I am too. Look, I want to say what is the approach here? What am I trying to do here? I've just made a case that the court has to maintain popular support at some level, and so it's so tempting to think, well, I'll tell you how. Here's what they do: hold your finger up to the political wind. And about half the country thinks that's what they do. And I want to say, I can't think of anything worse. First, they're terrible politicians. I mean, I've never met a judge. Maybe there are some, but I can't say I've ever met a judge. Maybe my brother, I don't know. Well, I have met very, very few judges, if any, who are any good at politics. And why not go to Congress if you're good at politics, or some other place? So really, it's foolish to try to decide things politically. And moreover, why would Hamilton have given the job to courts if they're going to decide politically? I mean, give it to the Congress or the president, someone who's elected. They're so much better at it. The reason we're there deciding things is so somebody will have the ability and the obligation to say no when the Congress has gone outside the Constitution's boundaries and it's unpopular to say no. All right, now, okay, then you say, well, what's your point here? What's your point? So if it's not politics, maybe it's just everybody deciding whatever he thinks is good. God, what a nightmare that would be. They'd all think something different was good. And every time you had a new judge, they'd have a new idea of what was good. And that's not a recipe for stable law. Say, oh, well, let's go and control the judges. Let's have originalism. Well, I have dozen well-chosen arguments why that isn't the right solution. And, well, what is then? And now, you see, I retreat to bumper stickers. And at this point, I'm saying, well, the bumper sticker is that I like one of them, that the values in the Constitution don't change. But the country changes. And so part of the job is to apply these changeless values to circumstances that change. Another good bumper sticker is to say, which I believe, that if you go back, there's a very, very old tradition in the United States that was that Gordon Wood describes well in his history of the just around the time of the Constitution being written, well put by a judge in Connecticut who said American judges, when they decide difficult appellate cases, they act, it's prudent and pragmatic. Those are the words, I like that, prudent and pragmatic. And then I can look at judges whom I admire, whom all of us admire, Learned Hand, Holmes, Brandeis, and say, well, look at what they do. I mean, that's sort of what it is. And then I can say, I better go a little bit further. And I can't ask you to read all my opinions, or all Brandeises, or all Holmes, or anybody I admire as well as more pedestrian than me. The reason I can't do that, too many. It's like, you know, the woman goes to the psychiatrist, said, why are you here? My husband sent me. Why? Because I like pancakes. What's wrong with that? I like them too. Oh, you do? I have 15 trunks full. Well, this is see, that's, all right. I mean, there we are. You can't do that. So what I've tried to do in about 100 pages is put enough meat on these bumper sticker bones so that you will lose any temptation you have to say there isn't substance to this. And I think there is substance to it, but you can't say it in 5 words. You have to show it, and you have to be able to show the direction in different areas: statutory interpretation, administrative law, human rights, what happens when the president is charged with the war power, and you have a situation where Congress and the president say national security requires this, but basic elementary human rights says that, and there's a conflict there, and the court's charged with the human rights part, and the president and Congress with the let's preserve the country part. And what does the court do? And Korematsu go into when they had the Japanese, 70,000 American citizens were put in camps. And I say there the court sort of abdicated. And we have Guantanamo where the court tried not to abdicate. I don't have clear answers. I want to show you what they've done. And I want to show you why I think they've done it. And obviously I think Guantanamo was right. I mean, we held against the president. I was in the majority. But I don't know. It will be a long time before people actually know. And I want you to put you in the dilemma that I sometimes am in, and we often are in difficult cases, where there is not good versus bad. It's good versus good. Those are the hard ones. Privacy. Free expression. Well, I mean, what do we do now? And you can't sit there and just say, oh, well, this is so interesting. You have to decide. All right, that's what I'm trying to do. I'm trying to put some meat on this bone so you get a picture of how this bumper sticker works when we have difficult cases in front of us.
You had this privacy and free expression case just yesterday, and you're struggling with it in front of us, weighing the values. And you know that I think that this has substance. But a lot hangs here, Justice Breyer, because this is the alternative to originalism for many people in this country, and they want to know how it works. So I'm just going to press you on a couple points, and we'll have it out. So you mentioned Korematsu and Guantanamo, and we've talked about this. But the criticism here is that are you being too accommodating? You said in the Guantanamo cases, yes, you can detain the citizen, even though Congress hasn't authorized it, but you have to have judicial procedures. You have to be able to confront lawyers. Some people said, well, why should the court have saved the president from his worst instincts and allowed him to have this system? Better to strike it down. Then later you said, well, if Congress authorizes the commissions, they're okay. But then in another case, you said, no, Congress can't suspend.
You're thinking of Guantanamo, you mean Guantanamo.
Yeah, the Guantanamo case. Even when Congress endorses the suspension. Mm-hmm. And then finally, in this passage that we've talked about, I think you're invoking Justice Barak from the Israeli Supreme Court. And he says sometimes deciding these security cases, judges have to balance these values of liberty and security that Congress and the president won't do, and they can strike a sensible balance. So the challenge is, are you being too compromising and implicating yourself in a system that basically should be left up to the political branches and saving them from their worst instincts in these terrorism cases?
It's such a good question, and I'll give you some examples. Obviously, since I decided it the way I did, I think the answer is no. I think it's fine, but that's the decision I came to. But and the majority did. But look, think back to this Korematsu case where we started. Some of you will remember it or know it. I remember it because I was about 7 years old when my mother drove me down in San Francisco to Tanforan racetrack, and she said that's where they kept the Japanese in the war, and the tone of approval was not in her voice. She thought that was a terrible thing, and it was. There were 70,000 American citizens of Japanese origin who were sent in 1942 January to camps in the Midwest and the mountain region. And the case got to the court. Fred Korematsu brought the case. His parents had been sent there. He was supposed to report and go there. And I'd actually met him once in his old age. He was, because our next door neighbor in Cambridge is the daughter of someone called Ernie Besig, and Ernie Besig was the head of the ACLU in San Francisco, and he represented Fred Korematsu. So I thought it was really interesting. And he said that actually the ACLU wouldn't represent him at that moment. They did later. They were in the case later. But Besig was on his own. And he did represent Fred Korematsu, a feisty guy. And he was under a lot of pressure from the Japanese American community not to bring the case. They didn't want to rock the boat. But he said, but they can't just send it. And he just felt this was totally wrong. He didn't want to do it. And they brought the case. It came up in 1944. And by 1944, which is so interesting, not only in 1942, January, people really thought the Japanese were going to invade San Francisco. They were really worried about it. And the 6th Army, General DeWitt, who was the head of it in the Presidio, said we have to evacuate the Japanese because we don't know who's a spy and who isn't. Now, there were people who later regretted it, but Earl Warren supported that. He said later, I regretted it very much. But the person most opposed to it, J. Edgar Hoover. And he told DeWitt at the time, there's no need. We have a list of 1,000 people whom we can pick up, and we will. And that list, if anything, overstates it. I mean, he didn't say overstates it. But he said, don't worry about it. We have the people we have to worry about, and it's not that 70,000. And this came out later. By 1944, the Justice Department knew that not only was there no longer a risk of invasion, but that in 42, DeWitt had known that there wasn't really a need. He had some things he based it on. He based it on elements of sabotage. He based it on signaling to submarines offshore. And these lawyers in the department, they were great. There was one called Burling and the other called, what's his name? I've dropped his name. But they called in the FCC and they said, look, was there really signaling going on from the shore to Japanese submarines? They came back 2 weeks later with it, like that. And they said, we've looked through we know everyone, all 751 instances that DeWitt referred to, and there isn't one. This was all mostly stuff buck privates just gotten into the Army. They didn't know how to work the equipment. And Burling and Ennis was the other. So he said to the FCC, but how did you get all this so quickly? He said, oh no, we didn't get it now. We had it at the time. We showed it to DeWitt. And they put a footnote in the brief. It was a famous footnote. And then they tried, the War Department and the Justice Department had a huge fight. And it ended up being mediated by Herbert J. Wexler. That's a name familiar to some of you. He was acting Assistant Attorney General in charge of war. And he wrote some stuff in there that kept these two on the brief. And because it sort of said. But if you read it very closely, you'd see the department's disowning DeWitt's report. And but you had to read it pretty closely. But during the oral argument, the ACL lawyer, Charlie Horsky, got up and made sure that every one of those 9 justices had read that footnote and taken in what it meant. So they pretty well knew, and they decided for the... Now, and these were not, I mean, it was Black, Douglas, Frankfurter, the people who later decided Brown. So you say, well, but it's really, and the people in dissent, Murphy, Roberts, and Jackson. I always think Murphy's totally right on that, Jackson had some complicated thing. He said what we ought to do, and this is why I like Brock, he said what we ought to do is we say this is unlawful, because if it ever is necessary to do something like this to save the country, the military will do it anyway. So let them do it and behave it unlawfully, unconstitutionally. They'll do it, they'll save the country, and we later on will say it was unconstitutional and save the Constitution. Perfect. Well, maybe. I used to be taken with that. I thought that was so clever and interesting. And, but I'm not anymore, because I think that approach has a couple of problems. One of them is that executive branch will decide to obey the law and the country will go down the drain. But perhaps the more serious one, or more realistic anyway, is they'll get into the habit of disobeying the Constitution. And that's a terrible idea. Terrible idea. So you say, Barack, that's because he's facing that problem. So I have the idea that law, and because the Constitution is not a suicide pact, it can't be. So law, civil rights, the Constitution, the need for protection, it all ought to work out. Now, Korematsu, they thought they couldn't get it to work out. They thought there's no way we can do this. Either Roosevelt runs the war or we run it. And we can't run it. So we just approve what he did. I think that's my view of how they were thinking. Have a judge now reading back those opinions then and looking at them with my own eyes and saying, I think that's what they did. Now, Guantanamo, see, Guantanamo, I think, was an effort to learn from Korematsu. We don't want to say blank check. Sandra O'Connor says that in her opinion. Not a blank check. But be careful. Be careful of going too far. Because there really are security risks. There really are dangers for the country, now or in the future. And be careful of tying the executive's hands, or those of Congress, to the point where they cannot act where it's necessary to do so for security reasons for the country. And so what you see in those opinions, in my opinion, of those opinions, which I explain why I said, is you see tentative steps. What you see is step by step. Don't have rules that go out too far. Leave a lot for the future. There were 4 cases. First case says a person in Guantanamo under the statute, it's part of the United States, he can bring a habeas corpus action in Washington, D.C. Second case says if you have a person, as this man was, who he said he was not an enemy combatant. You can hold an enemy combatant during wartime. It just said we're in Afghanistan now. He comes from Afghanistan. At this point it is a war, so he's an enemy combatant. He says he isn't. He says, I'm a shepherd. I was just picked up. I was a shepherd with my flock. And the Army says, well, why did you have a machine gun? And he says, well, we use machine guns in there. But anyway, there was a dispute, okay, a real dispute. And so he said, what are we supposed to do? The court says, the essence of due process, independent decision maker, chance to present proofs and arguments, not too detailed, not going into a long list. Third case, the least popular person probably in the United States, or one of them, bin Laden's driver. Bin Laden's driver is saying, they can't try me with a special tribunal. He is suing the most powerful person probably in the West, is the President of the United States, and bin Laden's driver won. Because the court said, the statute here does not authorize this kind of military tribunal. Fourth case, Congress got around to erasing quite a lot of what had been done by statute and the court's interpretation, and it said, in effect, that these people in Guantanamo will not be able to bring their cases up to the courts. Now, they had a special route to do it after the thing was over, and there was a question whether that was the equivalent of what's called habeas corpus, which but we thought it was not the equivalent, and we thought that it was unconstitutional for Congress to do that. Now, you see, you say, well, you should have been clear lines, and the dissent thought there should be clear lines. That's right. And I don't think so. There we are. I can just say there's a genuine disagreement about how far our opinion, exactly our opinion should say in those cases, a genuine disagreement, and we'll never know if we picked exactly the right thing, because you just have to hope that you've done your best there, and I can explain the attitude, which is right there in the opinion. But I can't prove it's right.
All right, good. So one line of criticism, and I guess this would be the criticism from the left, is the one that you've just described, that pragmatism is too accommodating, implicates the court too much in compromises that it really shouldn't be involved in. The criticism from the right, I suppose, is that it's too heroic. You say a couple times that if a judge believes that basic moral or constitutional principles are violated, they shouldn't be too pragmatic, regardless of the consequences. My question here is, are you too concerned about the idea that people may not obey decisions that are unpopular with which they disagree? There is a lot of literature, and you are a professor and a very good one, and it's almost conventional wisdom, candidly, in the Academy right now, that the court is not a big counter-majoritarian body. Most of the time, through most of history, it's, if not followed the election returns, basically reflected public opinion, and on the rare occasions, when it does something that a majority of the country really doesn't like, during the New Deal, for example, or maybe Roe v. Wade, it provokes a backlash that usually leads to a judicial retreat. So in fact, you're talking about Hotspur and Glendower. Is that too romantic a question to ask? Is the court basically generally going to do what the public wants and get into trouble when it doesn't?
That's a wonderful question for the historians and the people in the Academy who study it. And it is. No, but I know it is a serious question. And it's not one I really can answer. Because I'm not advocating following the public opinion. To the contrary, when I use the word pragmatism, and that's what made me very nervous about using the word, I couldn't find a better one. But I have a very, very special idea of it. I don't mean you go out and do whatever you think is good or works in individual cases. I mean that the object here is to find ways of dealing with kinds of cases that over the long run will help the Constitution and the law work better. For example, where we're talking about interpreting statutes. That's a fairly technical subject, right? Virtually every judge, I use a funny example. Do we have time for me to say that?
Sure.
Okay, here's what, for those of you who are not lawyers, here's an example that I found in a French newspaper, which I like, an example of statutory interpretation. A biology teacher is snails in a basket live to his class in Paris, and the conductor says, "What's in the basket?" Opens it up and sees the snails crawling around and says, "You have to pay fare for the snails." And what? He says, "What?" He says, "Yes, read here, right here in the fare book. It says, no animals on the train unless they're in a basket, and then you charge full fare." He said, "But they mean dogs or cats. They're not talking about snails." He says, "It says animals." Well, I mean, do they mean snails? And if they meant snails, why didn't he have to pay 20 fares? I mean, I don't know. There, you see, this is the job for the court. Now, I just use that because it's such a simple example. You get some words, hard to say what they mean, and you have to figure it out. And there, how do we do it? Well, we read the text. You look at the history. You look at tradition, like a word with habeas corpus has a big tradition around it. You look at precedent. What did people say before? You look at purposes. Why did they write those words? And you look at consequences. If you decide this way, will it further the purposes, or will it stand as an obstacle to the purposes? Those 6 things. And I think that there are some judges who say, just look at the first 4 insofar as you can. That's history, tradition, precedent, text. And there are others, but they'll look sometimes at the other 2. And there are others like me who say, look to purposes and look to consequences. That's important. Because we're trying to figure out what Congress wanted, or how to make Congress's statute make sense here. And that's always very important. The first 4 don't always answer the question. That's me. I say, of course the first 4 are relevant, but I emphasize the last 2. Now, that's an approach. It doesn't mean in an individual case you'll get to a pragmatically good result. Maybe you'll get to a pragmatically awful result. It depends on what Congress wanted and what they wrote into the statute. But the approach is an approach that I believe in the long run will help Congress and the courts cooperate, work better at creating law, help people understand who's responsible for what, and thereby know how to vote more intelligently, and thus will help the democratic process work better. Now, that's what I mean by pragmatic. It's in a big picture where you have a lot of ongoing institutions, and law is not just like a simple thing. It has all kinds of parts. It's a Rube Goldberg device that has lawyers in it, judges in it, clients, practices like stare decisis, statutes, constitutional provisions, ideas about how judges should behave. It is unbelievable. That's why we go to law school. You know, that's how law professors make their living. And so it's making that whole thing, trying to get approaches that make that whole thing work a little bit better. That's what I mean by pragmatic.
Should the consideration of consequences, this is the question I'm asking, include a consideration of a possible backlash? So Justice Ginsburg has said that Roe v. Wade was too expansive. If the court had ruled more narrowly, and only struck down the Texas law at issue and took into account the possibility of a backlash, maybe there wouldn't have been a backlash. Or an even more controversial example of pragmatism, which you don't talk about in the book. In 1954, the court strikes down school segregation. It's immediately obvious that bans on interracial marriage are unconstitutional. But Felix Frankfurter persuades the court that if they strike down the bans on interracial marriage in 1954, there's going to be a huge backlash that'll harm the cause of desegregation. And for the next, 13 years, the court makes up all these fake excuses for not hearing these interracial marriage cases because they're afraid of the backlash. Was it right to do that on pragmatic grounds?
Well, the court has power to take which cases it wants. They're not violating the law by not taking a case. So in the notion of when you take cases or not, it's quite often that you might not take cases you don't think they're quite ready, you think the others should percolate for a while. So that isn't so uncommon, that kind of thing. But recall this, the examples that you give are special in this sense. Most of what we're doing here, you've heard me say this before, like most of these things, but I think it's a good metaphor. What I say we're doing is, this is a set of boundaries. It's a constitution that says most things are decided democratically, but we have to take basic rights protected, some degree of equality, divide power, 3 branches, states and federal, so no one becomes too powerful, and we have a rule of law. So there are these sort of 5 different themes, and there are some details here. Those are boundaries. Now, we're, in a sense, the boundary patrol. And I used to listen to Sky King, King of the Mounties, when I was 6 years old, and I learned about life in the boundaries of Canada. It was very tough. It was cold. And it's sometimes difficult. Is abortion on the inside or the outside? School prayer, inside or outside? I mean, those are the kinds of cases. Now, even there, most of the cases, they were unanimous about 40% of the time, 30 to 40. We're 5-4 about 20 to 25 and percent of the time. And it's not always the same 5 and say 4. And much of the time, even in very, very difficult cases, they're not as difficult for a set of, I don't think the desegregation was legally difficult, but they had a few practical problems. And that, I think, led to that kind of thing. So where they're very open, where there are a whole set of special problems, you'll get the court thinking pretty hard about some of the things that you mentioned. And there we are.
Good. All right, I'm going to ask one more question, and then we'll ask for yours. You know I like the book, and after I wrote that very enthusiastic review, I got an email.
No, it's great.
No, it's a pleasure. And it's
write the bestseller list.
You should all read it. But I did get an email from a friend, another law professor, and I'm just going to read it because this is the tough question. He says, I think you go too easy on Justice Breyer. For me, all of Justice Breyer's claims about deference, humility, and institutional modesty and pragmatism are questionable given his votes in the school choice and partial birth abortion cases, and also, I think, in the recent death penalty cases. Is it unfair to think that Justice Breyer defers only strategically?
Yes.
Why? Tell us about those school choice, partial birth abortion.
School choice? The school choice case from Seattle? You mean
no. I think he means the vouchers.
Vouchers, tough case.
Zellman.
Zellman.
Yeah.
Zellman's a tough case.
Yeah.
Well, I wrote about that in my other book. It was less popular. But I wrote several pages on it, and I explained why I thought it was a tough case. And I also said in that book, I'm not sure I was right in that case. And I don't know. I thought, do you want to go back into that case? What were the other 2? They might have been easy.
Partial birth abortion.
Partial birth abortion, I was following Casey v. Polino. Casey v. Polino says right in it that, that's what it says, I think. I don't want to re-argue all my cases, even though I'm prepared to, because they're so right. But, it says right in it that if they're going to limit abortion, they have to have an exception for life or health of the mother. And I thought the Nebraska statute pretty clearly didn't. So I thought that was just following the precedent. And so you say strategic? I didn't see a way to do it. If I didn't see a way to do it, I thought that there it is. It doesn't have health of the mother in the statute. And Casey said, you have to have health of the mother in the statute as an exception, and it didn't. That's what I wrote. So the secret is, by and large, the best way, and I know See, that you have problems sometimes. I used to be a professor. I'm paid for finding difficulties in what other people are writing. But particularly since I've become more sympathetic to judges, I feel that the best way to find out what the judge really thinks is you read the opinion. And that's really, surprisingly, some people get amazed. How could anyone really think that? All right, they did. That's what they do, really do. The object of this job, if you do it well, is you put, and the same thing is true in conference. And I've seen that that's why conferences work in the Supreme Court, because people say what they really think. And the difference between a judge and a legislator is paid for a result. A statute says what to do. It doesn't tell you why. A judicial opinion, if it's a good opinion, explains why the judge thinks that that is the result. Now, I will say that I'm sure I haven't done it perfectly, and it sounds a little defensive, but that is what I try to do. So I try to put in the opinion the real reasons. Surprise! I mean, maybe that shows whoever wrote in that I'm sort of limited. Okay, then I'm limited, but there we are. I mean, I do try to put in the real reasons that I have. I don't have some other set of reasons. It wouldn't be much of a job, frankly, to be a judge. It'd be a pretty stupid job if you're there. I mean, if you didn't have the opinion writing task, which is to do your best to explain the act. You can't logically prove your position. You never can. There are always 2 or 3 or 4 good logical positions, but you can give your reasons, your honest reasons why you choose this position rather than that one. And the judges that I've known, and there are many, and well, you don't need me to defend judges. You see what I mean? It's very biased, but you see what I think. I mean, I think they do their job, and they're writing down the reasons that they think. It's not some big strategic game. It is. Oh, we are. Okay. Was there any other one there you want?
That's just great. Ladies and gentlemen, you see that the great pleasure of this book and the chance to meet with Justice Breyer is the opportunity to talk with him about the Constitution, to challenge him and ask him questions, and that's what we're going to do now. So please wait until the mic is brought around, if you could, before asking your questions. And yes, ma'am, right up here.
This seems to be a recent new idea of using retired Supreme Court justices. I think it's because some of the present Supreme Court justices have to recuse themselves from cases. What are your thoughts on that?
I think I better not have thoughts, because it's actually a legislative proposal.
Oh, I'm sorry.
No, that's not your fault.
Okay.
You can ask whatever you want. That doesn't guarantee. It's me who's at fault if I answer something I shouldn't. But I think I have to stay away from that one.
That's good. This is like a confirmation hearing. There'll be a little bit of dodging. Yes, sir, in the back.
Yeah, Justice Breyer, as I understand, I guess the bumper sticker version of your book, it's that the courts have an essential role in ensuring that our democratic process works. And I guess my question is, what happens when the democratic branches themselves aren't upholding their part of the bargain? And I'll cite 2 quick examples. One is, of course, in statutory interpretation. The typical rule is that once a statute has been interpreted some way, unless Congress intervenes, we're going to keep interpreting it that way because, if Congress didn't like it, they could change it. Well, we have a Senate right now which has erected over the course of many years increasing barriers to doing anything. So at some point you reach the point where Congress can't act. And does that change the court's role? And then a related question to that is, what happens when the courts themselves get hollowed out? We now have a 12% vacancy rate on the courts. During the same period in time when 7 judges were confirmed in the previous presidency, only 1 judge, Judge Jane Stranch, was confirmed by the Senate. So, do we reach a point where the courts themselves are unable to function because the Senate, itself is not functioning?
Well, you have to have support for the court so that they can function. Obviously, on the kind of slogan that you mentioned, which is a slogan, and you see it in a lot of opinions. Well, Congress can always change this, but I think I've always known, and judges have always known that some things have always been hard to change. I mean, you're not going to get an amendment of the Sherman Act I used to teach antitrust. And it's very, very unlikely that you'll get amendments of the, you could, but it's hard to amend the basic civil rights laws. And it's hard, there are a whole lot that are hard to amend. And I think we understand that. And therefore, it's a kind of, you don't see it too often. Well, Congress can always change it. And you do see it sometimes in cases where the judge is sort of hoping Congress will change it. And so it's a good question, and there we are. I mean, they do have the power to change it, and sometimes that's just difficult. But underlying your question, I think, is sometimes a constitutional case will come up where it has to do with the structure of the democratic process. That was true of Baker v. Carr. That was true of the one person, one vote, all those cases. And that's true of the gerrymandering cases, too. And the court held that we cannot intervene in gerrymandering cases because there are no remedy. I dissented there. And I dissented for the reason you suggest. I thought there were some instances of gerrymandering where the court could find remedies, even if only a few. And that it would be helpful, even in those few cases, to say that we have a remedy and the behavior and the gerrymandering is not. And the one before us was not constitutional. I put my reasons down. And the reason that I say in this book that if I had to choose one dissent that I'd like to have seen become law, it was that one, because of the concern with the process. And it is absolutely right that the assumption that courts can do their job is based on the assumption that we do have a functioning democratic process. But that's, of course, up to individual citizens. And that's why I said, first time I was writing about this, that all I can say in my expertise as a judge, I can't tell people what to do, but I can say I've gotten the impression that John Adams and all the others would have thought and did think that people will participate in that process. And if they don't participate in that process, the Constitution won't work. And I've gone on a little bit here to suggest that I think that with Sandra O'Connor, absolutely, the thing that's the most important is that the schools, 12th grade civics, that as the next generations grow up, they understand what this process is that's written into this Constitution, how it works, what the flaws have been. It's had problems forever, but we sort of overcome them eventually, and don't give up, you keep trying. And understand the history of this and the system well enough that they will participate in an intelligent way. So that's the theme of your question, if it is. And I tend to agree with that, if that's the theme.
Forgive a very quick follow-up, but you say in the book that the gerrymandering case is one of 3 dissents that you'd like to turn into majority opinions. I'm dying of curiosity. What are the other 2?
I can't remember. I'm sure I have.
That's for the sequel. Okay.
Yes.
I was curious. Yes, ma'am.
Justice Breyer, thank you for being here. I'm wondering if you could say something more about how the court goes about deciding what cases to take.
Yes.
And is courage. And
it obviously is more mechanical than you think. I mean, it's a very, very mechanical process.
Well, there's one additional aspect I wanted to get in, and that is that if you thought that a decision, one way or the other, might result in civil strife or governmental chaos, would that be a factor that would play a role in whether or not to take a case?
I suppose it would. I haven't seen that in... I think that would have been a good reason not to take the Dred Scott decision. It hasn't really come up, but I can see it as being a factor. I absolutely could, but because we have discretion as to what we take, but it's more mechanical than you think. We get about 7,500, 7,000 to 8,000 requests every year. We can only hear federal cases, that is, questions of federal law. That's about 5% of the law of the country. I mean, almost all the law in this country is actually state law. People don't realize that, but it's true. And we're just concerned with Congress, the Constitution. Right now, they've had trials, they've had appeals. Finally, people get up to the highest appeals court, and then there's only one place to go, us. So they ask us, and I say there are maybe 7,000, maybe 8,000. How do we deal with them? Well, it's about 150 a week, and what there are is these little papers that 15 pages saying take it, and maybe 10 pages or so saying don't take it. This is the issue we want you to decide. Right now, they're the law clerks in a big pool for the most part. 30, let's say they're 30, and they have 150, and they each write 5 memos. And so people say, well, why do you have the law clerks write these memos? It's your job to read that. And I say, well, there's something to that, but I'd rather have a human being called a law clerk who goes through 5, because some of them are just scrawled, and you think the person's insane. And well, sometimes that insane scrawl could be right. And if it is, and there have been cases where they have been right, and a law clerk doing 5 is possible to find such a thing. And I'd rather have that human being called the law clerk go through and write a thorough memo on 5 than to me pretend to read 150, because that's what it would be. So anyway, what I get is a stack like this of memos. Now I can go through those in probably a couple of hours and reduce them to this. And the question is, how can I do that so quickly? And the answer is not because I'm such a genius. The answer is because of what our job is, which was best said by President Taft, who became Chief Justice of the United States. He said the basic job of the court is not to correct errors. They've already had a trial. They've already had an appeal, probably 2. They better have caught the error before. Now, I'm not going to say never. Maybe it's a death case. Maybe it's some special thing. But by and large, no. But what is the job? He said the job is to create a uniform federal law in a case that requires that uniformity. Now, when does it require that uniformity? Probably if different judges in different places in the country have come to different conclusions about the same meaning, the same text. Some think it means one thing or applies one way, some think another, we're almost sure to take it. Almost sure. But if they're all in agreement, we're almost sure not to take it. So there can be special reasons. I mean, maybe a judge declared a statute unconstitutional with Congress. We'll probably take that one. And there could be something that we feel is so important that I mean, maybe we would have taken the Guantanamo cases without a split. But basically, we're looking for the splits. And we're getting that. Now, that's really the criteria. Now, even there, as I say, we don't have to, because it's a discretionary process. And by the way, it's hard to go wrong. Suppose we didn't take a case. And we really should have. There was the country really needed uniformity on this question of law, and we didn't take it. You see what will happen? It'll come back. It'll come back. It'll come back in another case. And suppose it never comes back. Well, I guess the country didn't need it. All right. But do you see? That's more. I'm being a little outline here. It's sort of an outline. Don't hold me to literally every word I'm saying here. But I'm giving you a picture of the somewhat mechanical nature of this process. And we end up with 70 or 80 a year, and people say, "Why aren't you taking more?" And I'm saying, well, you know, I'm sitting there in the conference and people are saying, let's take more. Can't we find any more? I mean, the mood is not take fewer. The mood is we probably could take 100 or so without too much trouble. But we haven't been able to find the splits that are serious enough that we think they should be taken. So there we are. We pretty much follow the criteria.
Stuart.
At least that's what we think we're doing.
Justice Breyer, I think either you or Jeff opened the door to Bush versus Gore. I don't recall which one it was.
It was him.
But if I can get away with
Senator Reed.
if I can get away with it, I'll ask a 2-part question starting there. And the question is this: Bush versus Gore is generally talked about as a 5-4 decision. The conservative 5 voted for Bush, and the liberal 4 voted for Gore. But I remember it as being a 7-2 decision.
You could put it that way.
In which you and Justice Souter also voted that Florida, in the Florida Supreme Court, had violated the Equal Protection Clause of the Constitution in the way the votes were counted. And then there was a 5-4 vote on whether that problem justified ending it now or giving the Florida Supreme Court another shot. And my question is which of those 2 holdings you think should be thought of as the definitive message of Bush versus Gore?
Well, where 7 of us agreed was that we thought that if there's going to be a recount, there should be a uniform standard throughout the state. You shouldn't have a standard with one thing as a hanging chad and the other thing as a flicking chad, and sometimes it counts and sometimes it doesn't. We thought there should be a uniform standard, 7 of us. But I think that most people have felt the key decision was the decision of the court not to have the recount. And on that, 5 people thought we won't have the recount, and 4 of us thought we will have the recount. Unfortunately, 5 is greater than 4, and therefore they did not have the recount. And I think that's the general view. I'd leave it to others to say which is the more important. I think it's important that they should have had. I thought they should have had a uniform standard. I agree with that. And there we are. I also think they should have continued with the recount.
Second part of my question is arguably related to the first, and it has to do with trying to figure out why the Supreme Court seems to have such good poll ratings relative to Congress. And I wonder, is it because you're better and smarter, have more integrity? What is it that when the Supreme Court makes an inherently subjective policy decision under the Constitution, that it seems to get more respect? And I wonder in particular whether it might have something to do with the fact that you don't take campaign contributions and you're not on television much. And if that's not it, what is it?
Well, that's a good question, and why? And that's the question that I was asked by, not quite in that form, but that's very closely related to the question of Chief Justice of Ghana, a woman who's trying very hard to get her court to be protective of human rights and to get that system, the democratic system, to work well in Ghana. And she puts the question to me this way: why do they do what the court says? Say, yours is an aspect of that. Absolutely. And you see, when I talk to her, I say, but I don't know. I can't tell you a simple answer. I can tell you some history. I can tell you some stories. And by telling you the history and the stories, I think you'll see how over time people, by and large, not everyone, has come to, which is such a hard thing to do, to come to the realization that it is a desirable thing to have an institution made up of fallible people who will try to enforce these provisions of the Constitution even when it's unpopular to do so. You see, to get that, you have to say to your friend in the marketplace, the supermarket, you have to have enough time for him or her or whatever to say, look, hey, you're going to have to support an institution that by definition is going to do things that will be unpopular, and that means you won't like it. And by the way, I'll tell you something else. They may be wrong. My goodness. And can we convince those people that nonetheless supporting of such an instance called an independent judiciary is in their interest? And I will say to the women in Ghana, as I did say, I don't know the secret of telling them that. I do know it has something to do with a long history of lots of ups and downs, which contained a civil war, which contained 80 or 70 or 80 years of legal racial segregation, which contained all kinds of terrible things. And sometimes the court was right and sometimes it was wrong, but eventually it's come to a situation where I can see in front of me every day, which I get the same thrill of, which is why I say so often people of every race, every religion, every point of view imaginable, and they're in that courtroom resolving their differences under law rather than through violence in the streets. And there we are. That's not to answer the question, it's to repeat it.
One last question. Yes, ma'am.
I was wondering what your thoughts, Justice Breyer, are on televising perhaps more proceedings of the Supreme Court so that the average American would perhaps feel a more connection to the Supreme Court decisions and the process that you go through?
That's a tough one for this reason. It seems to me that obviously if you see the oral argument is only about 5% of what we do. I mean, most everything we do is in writing. But the question is, should that be on television? And then when I think, but my goodness, what people would see is they would see 9 judges actually pretty much hard at work. I mean, we're not always at our best. Sometimes we ask too many questions too quickly, and the lawyer has a hard time. People get angry at us, but we are trying to do the job, and that would come across. And what also come across is that these are not so easy. After you read about it in the newspaper, perhaps depending on which one you read, it looks easy, but it sure wasn't. And that would somehow come across, and that would be great for the institution. It'd be great for the whole country, because they'd see there are things that work here, you know, it works. Maybe you don't agree with the results, but okay, they're trying. Now, were that the end of it, it'd be easy. But then people worry about other things. They worry about, well, if the cameras were there, would they be in every courtroom, in every case in the country? And what about a criminal case? Because we're such a symbol, you say. And what about a criminal case? And juries are worried about maybe being killed if they're on television, or maybe the witness is worried about what to say. And then some people worry, well, they just take sound bites, you know, and they have this nice one. One of the members said all the newspapers have 2 pictures of you, the members of the court. And if they agree with their decision, they put in the nice one, and they go, or would that kind of, or would it confuse people? Because, you see, people relate to people, which is good, the nice characteristic of human nature. And they say, well, this is a good guy up there, and here's a bad guy. And that isn't what the case is about. The case is really about 300 million people who aren't in that courtroom, and we have to think of how it's going to affect them. And so what will happen? Big question marks. Now, you see, they're worried. So who are we? We are trustees of an institution that had a long life before us and will have a long life after us. And so we're conservative. And therefore, we hesitate to make changes without being able to foresee too well. Now, I've explained this in more detail than I usually do, because what I usually end up saying is I'd like to see what's happened in states. I'd like people to study this who aren't paid for by the press, who aren't, you know, but they're good studiers, and they're maybe some of these professors who are writing you all the time, they'd get out there and they could actually get some information about how television does affect people's attitudes and what they learn and so forth. I would like to see some of that. So I put over this what I call a big question mark, which is a very unsatisfactory answer.
Ladies and gentlemen, Justice Breyer will continue the conversation. He will sign your books. I urge you to buy it. You can see from this remarkable man that you do not have to agree with his particular conclusions to be impressed with his thoughtfulness and his humility and the moderation of his message, which is so urgently needed and such a balm for our polarized age. Please join me in thanking Justice Breyer.
Thank you. Thank you very much. That was well. Thank you. Thank you. Thank you.